Hi, I'm Kyla Lee at Acumen Law Corporation, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about Indigenous people and juries. Cases that should have gone to the Supreme Court of Canada, but didn't. After the recent Colton Boushie situation in Canada, there was a huge uproar about the makeup of the jury in that case. Mr. Boushie had been killed by a non-Indigenous person. He was Indigenous, and the jury was primarily non-Indigenous people. One of the issues that arose in the political discourse that was the fallout of the acquittal in that case was whether there should be more effort made to make up juries that are representative of an actual population in an area. The Cornell case dealt with this as well. Mr. Cornell, who was an Indigenous person facing a trial by jury in the Yukon, applied for his jury to be done with 25% Indigenous people. That application was denied by the court on the basis that the jury selection process was done according to the law about jury selection, and therefore it was fair, even though he didn't have an Indigenous juror on his trial and ultimately was convicted. This case was a really interesting and important opportunity for the Supreme Court of Canada to get into these racialized make-up issues that plague juries not just in Canada, but in the United States and in plenty of other countries that deal with a jury system. When you have a huge history, as we do in Canada, of Indigenous people being marginalized and institutionally marginalized and put in a position where their actions and decisions may be motivated by historical marginalization and colonization, it's important for the Supreme Court of Canada to say, maybe the jury selection process doesn't do good service to Indigenous people. After all, we already look at sentencing differently in an Indigenous context. Why can't we look at jury selection and trial makeup differently? We have First Nations courts across this country that deal with Indigenous matters in a culturally contextual way. Why is it that we can't do jury selection that way? Particularly in places with a significant proportional population of Indigenous people, but not represented on juries. The Supreme Court of Canada could have fixed what is clearly identified as a problem in this country. They could have found that it is appropriate, considering the history of Indigenous people, to alter the terms of jury selection to make up a fair and representative jury. Unfortunately, they did not do that. And it's a really disappointing decision in the wake of the political fallout that we see from the Colton Boushie decision. I'm disappointed that the Supreme Court of Canada didn't take this opportunity, and I hope that in the future, other lawyers facing jury trials with Indigenous clients will bring similar applications so that the Supreme Court of Canada can see this again and can see how important it is to Native people in this country that we do things correctly. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, share, and tune in next week for another video.